So we asked the court to reconsider, and the court actually did reconsider. It acknowledged its error.
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
Today we're diving into a key issue in commercial foreclosure litigation, specifically the enforceability of default interest rates and which party bears the burden of proving whether those rates are reasonable. We recently had a motion denied where the court improperly assessed the reasonableness of the default rate on its own, despite the law clearly placing that burden on the borrower. In response, we moved for reconsideration, arguing that under the New Jersey Supreme Court's decision in MetLife v. Washington Ave Associates, it's the borrower who must prove the rate is unreasonable. The court ultimately reversed itself and upheld the default rate in the note. Joining me today to break down the legal framework, our strategy, and the impact of this ruling is Senior Associate Quenten Gilliam. How's it going, Quenten?
It's good.
Before we jump into the case, let's just talk about the default interest rate and like what we're talking about and what we mean, right? So when is the default interest rate imposed?
In commercial loans in New Jersey, the parties contract to set a rate of default interest.
To an outsider, they would say, look, you have a contract, you have a note, and the borrower, who in this case, a commercial entity or a corporate entity, they agree if they default, they're going to pay a higher rate.
That's right.
This sounds so simple. What's the problem? Like, why is this even a topic?
So in New Jersey, there's a rule that says that the court has to make a determination that the default interest rate is reasonable.
What would make a default rate unreasonable?
The MetLife case said that the rate in the contract is presumed reasonable, and it's the defendant's burden to show that it's an unreasonable rate. The reason that the Supreme Court of New Jersey said that is because damages are difficult to predict at loan origination. So the parties might not know what the market conditions would be 10 or 15 years later if there was a default. The parties might also not know if the case would have delays due to bankruptcy or foreclosure or very high legal costs associated with those proceedings.
All right. So in essence, the reason why reasonableness matters is because a rate is going to be a multiplying factor of the principal. And we don't know how long they're in default for. We don't know what interest rates are far into the future. We don't know what lending tendencies are at that point in time. So the court will make sure that it's reasonable as it pertains to what will be charged at the time the default rate is applied. Is that kind of the point?
Yes, that's the point.
Okay. One other question before we get into the case, because this is what I'd be wondering if I was watching. Doesn't New Jersey have a new usury law? Like, why is that not reasonableness? The government sets a penalty. If you charge above this interest rate, that's criminal or gives rise to a civil cause of action. Like, why is that not the determining factor? Why is it reasonableness?
So just because a rate might not be in violation of a criminal usury statute doesn't necessarily mean that the court will find it to be a reasonable default interest rate.
All right, so what happened here in this case?
So we had gotten a motion to determine the reasonableness of the default interest rate denied, and the motion was not opposed by any party. So we decided to fight back, and we filed a motion for reconsideration, and we asked the court to reconsider his determination, and we reminded the court that under the MetLife case, the rate is presumed reasonable, and it is the defendant's burden to show that the rate would be unreasonable. In this particular case, since the motion was unopposed, no one had appeared and nobody had met that burden. So we asked the court to reconsider, and the court actually did reconsider. It acknowledged its error. It said that it had improperly shifted the burden onto the lender, and it changed its mind and found that the motion to determine the reasonable interest rate for the default interest in this case should have been granted.
On the basis of what you're saying, do you believe or would you argue that any motion to determine the reasonableness of the default rate, if unopposed, should always be granted?
I would say so, because the burden on the non-moving party that the Supreme Court set forth in the MetLife case.
Are these types of motions where we're seeking a determination that the default rate is reasonable, Are these commonly opposed?
I would say they do get opposed sometimes.
Was this a big surprise that the court shifted the burden?
It was a surprise because the motion was unopposed. Where a motion would be opposed, then the court would have to decide whether or not that burden was met by the non-moving party, in this case, the commercial borrower.
So if I'm a lender and I'm a commercial lender and I'm going to, have default interest rates in loan docs, obviously if I put this into my loan docs, I want it to be upheld. I want it to be determined to be reasonable. What's something from the lender side that they can be thinking about to ensure that their rate will be determined to be reasonable?
So first of all, when the parties agree on a specific rate, that would be the plain language of the agreement, and that holds weight in a court of law. So for the parties to both sign off on a loan document that has that rate, that would certainly help. In addition, a lender could look at industry standard and custom to see what's normal in the industry, and they could look to see what their actual damages might be in the future if there is a default.
Do you think a court would consider the creditworthiness of a borrower? Like if a lender wants to make an abnormally high default rate that's still below usury, would a justification for reasonableness be it was a very risky borrower?
I think it could certainly be one factor that might be considered among others by the court.
Interesting topic. I know this is an area specifically in New Jersey that's created some delays in the past, and just ensuring that everything is granted. So I think it's an interesting topic, and I think understanding where that burden lies is really important when a lender is contemplating what they believe the default rate should be. Thank you for joining Quenten Gilliam and I on the Weekly Friedman, your source, the most essential information in the default industry. Thanks for tuning in. Looking forward to seeing you next time.